Hey everyone, you are all very welcome to this breakup club where we will be discussing the topic of cohabitation and separation as an unmarried couple. I hope this evening will be informative as cohabitation is actually the fastest growing family type in the UK. In a nutshell, cohabitation refers to unmarried couples in a relationship who are living together. There are actually 3.5 million people in the UK living together unmarried, which is a really interesting stat. So this is going to be a really vital and important topic that we're covering this evening as it affects so many people. My name's Ciara Pugh and I'm your host for today. I'm a solicitor at Stowe Family Law and I deal with all things family law. I advise unmarried separating couples, and that's one of my specialisms. I'm also a member of Resolution, who are pioneers in campaigning for cohabiting couples. So I'm very excited today. I'm joined by Tom and Tara. So firstly, we have Tara Lyons, who is a barrister at Pump Court Chambers. Tara and I have worked together for, I think, 5 years now, Tara, and she's my go-to barrister for representing unmarried couples who have disputes at court. So if I let Tara introduce herself and say hello to everyone.
Thank you, Ciara. Wonderful to be here. I'm Tara Lyons. I'm a barrister at Pump Court Chambers, and I head up the cohabitation team there. I've got a large practice, not just in financial remedies on divorce, but also on cohabitation disputes. And as Ciara rightly said, this is a growing area and something in which it's really important to get specialist advice. So I am looking forward to discussing this topic tonight and amongst such lovely panelists. Thanks, Ciara.
Thank you, Tara. And then last but not least, we have Tom Nash, who is a divorce coach and someone I regularly recommend my own clients to. He guides separating couples through life's difficult transitions with compassion, clarity, and dignity. So over to you, Tom, to say hello, please.
Hello, everybody, and thank you very much to Stowe for inviting me back again. We've done a number of these talks, always love doing these. So yes, my name's Tom Nash, otherwise known as Mr. Divorce Coach. I'm a diploma-accredited coach, specialist divorce and separation coach. I help and support clients, both individuals and working with couples, to deal with all the stuff that the formalities and the legalities aren't designed for. So the emotional releasing and processing, rebuilding yourselves, looking at practicalities like effective communication, co-parenting plans as well. And as we've all said so far, a growing space for modern family dynamics is that not everybody is married, and that can bring its own set of unique challenges, both emotively and practically.
Thank you, Tom. So just a reminder to everyone that this session is recorded. It will be put on our YouTube channel afterwards and emailed out to people who have registered. We've had some really great questions that have come through already, so thank you so much to everyone who sent in questions before. We've kind of jam-packed them all together and we've come up with 6 questions that will hopefully cover everyone's burning questions that have been put through. So please do feel free to ask questions in the question and answer box as we go along. We'll try and answer some as we go through the session, and we'll also have a Q&A at the end of the session. Please do keep names anonymous, as will we, and don't worry if we don't get to answer all of the questions, because there's a number of ways that you can get in touch, and you can always reach out to our client care team after if we haven't covered it. So with further ado, let's get started. So our first question that we've kind of put into one broader question is, my partner and I own a house, but we're separating. What do I do about the house? And this is obviously the most common question that I'm asked. And the answer does depend on certain things, such as how the property is held. And it can also depend on what can be agreed between separating couples, as well as the legal stance. So Tara, if you have any thoughts on this question as well, it would be great to hear.
Thank you, Ciara. So I think the first thing that you will need to understand from a legal perspective is how you own the property. Now, there is a difference between the legal title and the underlying beneficial interests of a property. Now, most times, particularly since 2014, when the transfer deed, when you purchased a property, contains a declaration of trust. And so in the ordinary course of events, the underlying beneficial ownership will be set out in that document, and that will be final as to how you would hold it. There are two principal ways that you might hold it. You might hold it as joint tenants. That's a case where both of the owners essentially own the whole, and the key difference between that and what I'll come on to, which is tenants in common, is that you will, if one of you passes away, the whole of the property would pass to the other by something called survivorship. Alternatively, you might own the property as tenants in common, and that's when you would own the property in divisible shares. There can be, under the in the transfer deed itself, it's possible for you to own it equally, or there is also a box which sets out that you can own it in other shares, which would have probably been discussed and agreed by you when you bought the property. Under English law, the first port of call is really going to be how you own the property. But if you are married and if you are unmarried and have children, the court has power beyond dealing with it as an ownership issue. The court has power, and this is something we're going to come on to make certain provision in respect of property and capital in order to meet the needs of the children, and we'll dig into that in more detail. So that, in a nutshell, Ciara, I hope, is setting out the different ways you might own a property. I guess the only other thing to say from a legal point of view is, if that box isn't ticked on the TR1, if you have contributed to it, or there's been an intention that you own the property legally, even if it's in someone else's name, you might be able to establish what's called a constructive trust. And that's something which the courts readily do if there's evidence of contribution and an intention to hold the property jointly with someone else. And that's probably where we get into our thornier types of cohabitation disputes, the ones that take the most energy and require the most attention. But I'm pleased to say that more often than not, actually, ownership is set out in the TR1, and there is more times than not a dispute. So that's good news.
Really helpful, Tara. Thank you. And I think it's really important as well to explain to everyone kind of how the two ways you can own property are, as you touched on. So you can either be joint tenants or tenants in common. And that obviously impacts, if you're joint tenants and one of you were to die, the property passes automatically to the other, and that's known as the right of survivorship. And then if you're tenants in common, that doesn't automatically happen. Okay, so I think that's what's quite useful as well for people to know, because, you know, whenever I bought a property, they just give you a form and say, do you want to be joint tenants or tenants in common? And you think, well, I don't know what this means. And you just tick a box and you just want to get on with buying your property. So it's really important that people understand that, how it's held, because that obviously then impacts what happens with the house as well. So thank you for that, Tara. And Tom, if you could just help as well and explain a bit about the emotional and practical support for couples separating who are living together.
Yeah. I find with clients that I work with, and there's also a lot of research around this, that actually unmarried cohabitants that are separating due to the kind of the lack or the loss of the ritual of a divorce, it actually can quite often heighten the emotional and also practical challenges, as well as obviously the legal ones that the two of you are going to be talking about today. So living with someone kind of post-separation, kind of increasingly common for a number of factors, typically kind of financial constraints, maybe housing market realities, things like that. So it does create a very unique kind of emotional pressure cooker. So the things that we need to think about and consider, excuse me, is setting out very intentional, structured, formulate boundaries as well as self-care. Right? So first of all, acknowledge that this situation is really difficult. Right? It's going to be really challenging, right? And to not try to ignore that, right, whilst we're actually going through everything else. So maybe looking at kind of bringing in or practicing maybe some emotional detachment techniques, good self-care routines, as well as more practical things as well that we can look to bring in, because you're still grieving the loss of someone and the loss of a relationship and a life that you thought you had. Right? In terms of some kind of practical tips and techniques and that kind of boundary setting, where possible, and this can be quite light or quite detailed. And one of the things that I'll do is people actually, with couples, if I'm working with an individual or a couple, is maybe look at exploring how we can create kind of like something equivalent to kind of like a roommate plan, right? As you would maybe with a co-parenting plan and things like that, but changing it to the focus of the two of you and how you're operating. Things like designated separate and private spaces, right? Even if it's just your one corner of the living room, right? Establishing more certain things that need to be schedulized to minimize any overlapping situations that might cause any emotional charge. Right? I had unmarried cohabiting clients a couple of years ago where they actually even started incorporating a bit of a co-parenting plan because they did have a young child as well. So they actually even had handovers of the time for the responsibilities within the household, and it made it a bit easier when they did then come to move out later on. Right? So maybe like a temporary flatmate type scenario. But we also want to be setting out things like clear ground rules around like what's still shared expenses, responsibilities, but also things outside the home, right? So maintaining our own positive support networks, having good regular check-ins, friends, family, right, for that essential emotional release. Also planning activities to be outside of the property for yourself, but equally for your ex-partner, and actually so you've also both still got time actually in the home as well, personally by yourself as well. Something else that can sometimes come up when we're kind of talking about these practical and emotionally triggering situations is if one party's maybe started or starting or has already been dating already, right? So discussing how to handle situations quite sensitively around that, about a shared living space. And it's all coming back into how we're communicating about it, what things are, what these conversations that need to have kind of neutral formats, where can we have these discussions, how are we communicating this, formulating it into something of a loose plan, obviously not legally binding, but just setting out some house rules. One of the other things that I would say is actually how we bring back in kind of sense checking things, because quite often, and we see this with co-parenting plans, people set that out, make a rigid or what feels like quite a rigid plan or kind of arrangement, and then we kind of get stuck to it. And actually we need to try and test what's working, what's not. So are we meeting maybe once a week for a 15-minute check-in to just purely talk about what is and isn't working, if it's kind of things around the house and maintenance, as well as things like that. I hope that's helpful.
Really helpful practical tips as well to navigate parties through that. So thank you very much. I think as well, just maybe one thing on this question that Tara and I probably need to address as well is the myth of a common law spouse as well, because this is something that people are led to believe is a thing. I don't know where it's come from, because it's never been law, but people think, you know, if they live together for 2 or 20 years or, you know, even longer, that they are then entitled to the other party's finances because they've lived together. And that's not the case for cohabiting couples. And I think that's something that's quite important to address when we're answering this question, because it really is, if the house is owned, it really is just going to be about the house if it's owned jointly together. And then if there's children, as you say, Tom, there's parenting plans, etc., and there's agreements that can be reached in respect of the children. But it's important that cohabiting couples do know that they don't have claims on, you know, pensions or income or anything like that as well.
Yeah, I think the key thing that I know a lot of my clients have really struggled with is exactly that situation where they have essentially lived as husband and wife, except been unmarried for many, many years. They've shared their home together, they've shared their finances have been completely intermingled, and they've raised children, even if they haven't raised children. You know, they really have lived a kind of joined up life financially and emotionally, and that's a really, really hard thing. The separation or the division of a property can be quite a blunt tool. You're dealing with the Trusts of Land and Appointment of Trustees Act 1996, and it is literally dealing with the shares of a property. Now, that's not to say just because at the outset of a relationship, one of the parties bought the property in their sole name, that the other cohabiting party would not have a claim. But a lot of it is going to come down to what their intention was when they were buying it. Whether that was vocalized in writing, set out in writing or not, and what evidence they have to really support their assertion that it was intended that it was to be a joint home. And the courts are becoming much, much more sort of adapt to the idea that a contribution from the party, a relevant contribution, doesn't just have to be financially, but most times they are the stronger cases to run. So it is a difficult area of law, and unfortunately for unmarried couples, the provision for children is necessarily less generous than if they had been married, because, for example, as we'll come on to, under Schedule 1, you might only get provision for a home settled on a party for the minority of the children. So that's not outright provision. But as I say, we'll look at that. And I think we've got a question already that's coming, Ciara, which might actually we might also touch on when we're dealing with the question about what happens when there are children.
Absolutely, and we'll come on to that. And I think what you said there, Tara, is really helpful because it leads us on quite nicely to our second question, which is, we're separated and my ex has moved out to live with a new partner. They want to sell the property, but I don't. Can they force me to sell? And thank you, Susie, for putting it on the screen. That's very helpful. And I mean, this is, you know, quite a typical scenario that we come across. And one thing I would say on this is what can be agreed. What can be agreed between you and your ex-partner first and foremost? Because if they are really rigid in that they don't want to sell, or sorry, if you're really rigid and you don't want to sell, then what are the other options? Could you afford to buy them out potentially? Is that something that is something you're able to do? And that's where you might want to speak to a mortgage broker, see if that is a financially viable option for you, where you can buy them out. You would firstly need to agree on a value for the property with your ex-partner, so then you can agree a sum to buy them out at. That is always an option. And if, you know, if they're being really difficult, something you could do is explore mediation. So that is known as non-court dispute resolution. And it's really helpful because it can be a quicker way of determining the dispute between you. And it's a sort of round table with you, your ex-partner, and a mediator who can help guide you to coming to an agreement together. If mediation doesn't work because it is voluntary and you don't have to do it, you can instruct a solicitor who can help you and point you in the right direction. Court is always a last kind of port of call. So Tara, in this sort of situation where one party does not want to sell, but one party does, what would the kind of recourse look like through the courts?
Well, I think Ciara's made some really helpful points about non-court dispute resolution and the incentive on parties to engage in that, even if an application is made to the court, is really quite strong, particularly because any application would be made under TLATA, Trust of Land and Appointment and Trustees Act. It's a civil jurisdiction, and there is quite a lot of case law which basically supports a practice direction that has been made under the CPR, which requires the parties to mediate. And as Ciara says, last port of call, it is court. But sometimes it's necessary for an application to be made. And if a party is wanting a sale of the property, that would be an application by Section 14 of the Trust of Land and Appointment of Trustees Act. We call it TLATA. And the court would look at a number of considerations to see whether a sale was appropriate. It may not always order a sale, particularly if there are children involved, and if the court was at all worried that the children would not be appropriately rehoused, maybe because the caregiver had absolutely no mortgage raising capacity, and if there were other assets which might allow the other party to actually effectively rehouse themselves in the meantime, the court may look at a delayed sale for the child's minority. But most times, if there are available assets which could mean both parties could rehouse, the court is going to order a sale. And that would be at a trial, if not agreed before, but that really does happen very rarely. I practice in this area, and I would say that the vast majority of cases settle at mediation or immediately thereafter. So even if you're in the unfortunate position where an application has to be made, that doesn't mean you're finding yourself in a trial with all the necessary expense that comes along with it. I would just say that if there are children involved, it may be that the other party who wants to stay in the house is able to mount what's called a Schedule 1 claim, which is a claim concerning the children, where the court is going to be very, very much concerned with the needs of the children. And one of their primary needs, obviously, is their housing. So it may be that even though you might have a good claim under TLATA, which is just what happens to this property as a matter of ownership, that a sale could be prevented. There are other claims that can be made if someone has been kept out of a house in terms of an account for an occupation rent from the person that remains in the house. But usually those claims only succeed if the person that has moved out continues to pay for the mortgage as well as paying their own rent. But it allows there to be a sort of evening up if there's been a perceived unfairness by the court because of the length of time they've been kept out of their property. So there are kind of ways to do a balancing act there.
Thank you, Tara. Thanks for explaining equitable accounting as well to everyone. And Tom, just because we've touched on court, do you have any top tips for preparing for court, or how best can you kind of guide people through that?
Yeah, in terms of kind of preparing for court, of course, as I'm saying, should be kind of last resort, but actually preparing for it and kind of helping to start lessening the fears and anxieties around it at an earlier stage, even though we don't want to kind of get to that stage, can actually help us strengthen our kind of negotiating positions as well, help us understand what maybe our bottom lines are, make more informed and better decisions to go into processes like mediation and etc. that you were just discussing. So in terms of kind of practical steps, of course, kind of documenting everything, right? All kind of communications, understanding financial contributions, right? Gathering those financial records, so on and so forth. As you guys have already said, getting those property valuations and understanding your legal position. But one of the other things is not just about the legal position, but also calculating what that court process might cost in those legal fees can often motivate where there might actually be a potential settlement. Right? If it looks like it's going to be quite a long, drawn out and expensive process for them. Right? So considering what we might accept in court versus what we also want as well. So it's helping people understand their needs and wants as well. And one of the things that I was going to say is, I mean, this is very common. It is a really difficult one. We've got in this scenario someone who's at a situation where trying to find common ground when their interests are kind of going in different divergence, right? The ex wants to move on and has moved on both physically and I would hazard somewhat of an educated guess emotively here as well. So they're looking for closure, right? Whereas the person asking the question here is wanting and needing stability and some time, right? And both those positions are valid to one another. So it's then looking at and exploring. Let's look at things like what's the motivations that sit underneath it all. Is the motivation to sell, is it purely financial, right? Or is it also an emotive disconnection, right? Or that they're trying to move on emotionally? And also, what is it for this person as well? Let's pose this question. Is it actually about an emotive connection to the property? There was, I think about 3, maybe 4 years ago, there's a piece of research about where one party retains the family home, kind of quote unquote, through a separation and or a divorce, and actually inside 18 months or less they sell and move anyway, because once they have worked through that emotional disconnection, not just the legal and financial ones, and actually they've sat there and realized that they're sitting around in the bricks and mortars of a property that have now kind of emotionally disconnected from, and it's actually now beginning to hold them back from starting their new life. And starting that new identity for them. So I would look at both, trying to explore and understand both the ex's motivations and your motivations for wanting to stay. You mentioned about alternatives, Ciara, about can you buy them out? Can you also delay that potentially for 6 months? But framing it in a phrase of not, I don't want to sell, but more, I need 6 months to save for a deposit, right? Or if it's the market that's maybe not that might be affecting that you're wanting to achieve a higher value potentially, could practically, and again there'll be a whole host of different things like buy-to-let mortgages, so on and so forth, but could the property be rented out for the short term whilst the two of you come to your financial arrangements, thus still allowing you to be able to move on yourself both practically and emotionally, but covering those costs if there's also a financial element? I did have someone many years ago who had a very lovely substantial home with multiple rooms. They were also suffering from a bit of loneliness and feeling alone. Those things are different, and they actually ended up bringing some lodgers because it also gave them some connection and human interaction, and they and just being around other human beings as well, whilst also managing the financial impact as well. So there's lots of different little things that we can do.
I think that's really helpful as well, what you say in terms of so many options out there. And that is why non-court dispute resolution is so powerful, because you can voice those concerns as well. And you can say, look, I just need 6 months before I have to sell, for example. Whereas, you know, maybe a court wouldn't be amenable to that.
So
And
it's about retaining control, isn't it? Because ultimately, you know, it's you and your ex's lives, and actually there's nothing worse really than a court imposing their solution if actually it's something that you two, even though you've separated, could work out between you. And actually I think one of the questions we'll come on to deals with what happens with you know, our dog. And it's the sort of thing that actually the court is a very blunt tool on. But if you're mediating and having all of those discussions in a really safe, supported environment, such as mediation, you can work out so many other things that you really want to work out for your kind of emotional well-being, and not just for pounds and pence, to get a solution and move on with your life.
And what you say is so right. So I was just going to say, what you say, Tara, is so right, not having an order imposed on you, because more times, you know, people don't walk away punching the air from court thinking, oh yes, you know, I really got what I wanted. It's usually a compromise as well. So it's something to really consider before making applications as well. And that was right what you said, Tom. Thank you for that. It's really helpful. I jumped in front of you there. What were you going to add?
No, I was actually just going to say, and in terms of kind of communication techniques and things like that, and to keep track of things and to have things formalised on your paper trail, of course, keeping these as written communications through email. But one little thing that might actually help as well is, I mean, our worlds are wrapped up in these little things, right? And our WhatsApp pings off and the email goes and things like that. And that in itself can be anxiety, stress, and emotively inducing. So quite often with clients, what I actually say to them is set up a completely new email purely to manage all of the formalities and the process, right? And everything that has a legal or financial impact to it. And go and put it, if you use a Hotmail, go and use a completely different provider, because if you set up a separate Hotmail, it can sometimes sync on your devices. But what that then gives you is also your own self-boundary and your own self-control about as and when and where and how you choose to access that. And you can limit the notifications, freeing up the rest of your digital world, so that when you're booking tickets to a concert or whatever it might be through your email, etc., you're not also having your hot buttons pressed and going into that kind of trauma state of fight, flight, freeze, fawn by seeing their name at the top of your inbox. So centralize it, streamline it, and then you get to be in control of as and when and how you look at those and manage those communications.
Thank you, Tom. I'm going to move on to our next question because I am conscious of time and that we're only on question 3. So this question, we can't decide what to do with our 2 dogs now we're not together, but we don't want to rehome them. What do we do? And this is a really difficult question because as an avid dog lover myself, I totally understand. And Tara touched on it there, but as pets are just seen as something called a chattel in the eyes of the law. So they're no different than your, spoons and your forks and your Russian China dolls and all these things. They're no different, unfortunately, how the court sees them. There's reform at the minute that people are working towards. An ex-colleague of mine is in terms of reforming the law in respect of pets, because obviously pets are, to some people, their children, they're everything. I think Lewis Hamilton's dog died recently, and he's beside himself, and he's taken 2 weeks off work. He's not going to anything, and I can understand and sympathise with that. So yes, I think with that question, it's really difficult, and that's why it's about having that communication and utilising those tools to make sure that you can come to agreements together. I've had clients that separated years ago and they still share the dog and still manage to do that. And that's really admirable. Something else that clients consider is something called a pet-nup, which is essentially a kind of fancy name for a sort of separation agreement, really, where you can set out clearly what the arrangements are going to be. I mean, people do it with children, so why not do it with pets as well? So yes, I don't know if either of you have any more thoughts on this question.
Well, I was just going to say really quickly, just carrying on from what you had said, Ciara, it's right. Basically, the law sees your loved pooch as a chattel. And so what that means is, in terms of the orders it can make, it can only really decide who retains it. It couldn't, for example, create a regime of, shared care like we have with children. And so that means it's going to be one or the other. As I've said before, it's a really blunt tool. And often it's one of the emotive things that a couple are dealing with when they break up. Now, as Ciara said, that you can have what's called a pet-nup. Essentially, you can contract into an agreement either at the outset of your relationship, during the relationship, or at the end. And they are becoming more and more common. And there are developments in the law in terms of, I think previously, the sort of only consideration would be, well, who bought it? And that person would be the one retaining it. There's been a recent case appropriately named FIDO, FI against DO, obviously anonymized in a way so us lawyers can remember it. And in that case, the court was looking more at, who the dog really had a home with and who would best meet the dog's needs. So a creep towards the sort of considerations you as an owner would want to think about, but unfortunately not as advanced enough to decide any pattern of contact or shared care. So again, another plug for mediation, because that's when you really could resolve it between you and your ex, with the support of lawyers or without the support of lawyers, however which way you wanted to do it. Yes.
Thank you, Tara. And then in terms of kind of communication with the division process of pets, etc., or chattels, if we want to call them that, which I don't like. But Tom, have you any top tips on that?
I'm going to call them fur babies because we have dogs. Yes, I've actually had a number of clients, particularly over the last kind of few years post-COVID, where actually this has become more common. And I know of a number of clients who have actually used some of the very commonly and fantastically usable co-parenting apps for their pets, for their dogs. I know someone actually used Our Funny Wizard, for example, which is a very, very good one, and that did use that for their Dalmatian. And again, helping to build principles and handovers, transitions, timetables, notifications of when each of them are going to be away, sharing of costs for XYZ vet bill, so on and so forth. Dividing kind of, you say chattels, any other kind of possessions, and in this case, of course, a living being, right? That division and the discussion over the discussion that triggers loss, memories, sometimes even a desire to maybe win or feel validated, right? And with a pet being a living being, it just adds another complex layer to it. So I think from a communication strategies perspective, we need to start from the principle that we both love these dogs and we do want the best for them. Right? And actually separating out the pet's conversations from any other form of property division, because just like Lewis Hamilton's dog, they absolutely deserve their own conversation. It's also then starting to being honest and real about our capacity for what that co-pet ownership might be. Right? Does one of us work 12-hour shifts and things like that? Can we actually take them on more during the week? Right. Other things to start also discussing is discussing worst case scenarios as well, calmly and effectively. Right. If something was to happen to the pet, or if one of us has any kind of major life changes, be that changing careers, so on and so forth, right? And again, a bit like I would say exactly the same with co-parents, right? There's regular check-ins around the arrangements. Are they still working? Do we need to adapt them? And you've actually got a lot of the other tools that get utilized around informally around co-parenting and children that we can actually just adapt and transfer across. So those conversations and practicalities are the same.
Thank you, Tom. Okay, moving on to our next question. So this one's really important, actually, I think, for unmarried parties who are separating, who have children. So our children are both under 12 and have struggled with our separation, especially since my ex moved out and he won't pay child support. What can I do? This one is a question I get day in, day out. And Tara, I'm sure you do too, but you kind of deal with it on the other end, i.e. in court. And this one's really important because, you know, the parent, the non-resident parent, does have to pay child maintenance for their children. And there's kind of a government calculator that you can, if you just type into Google child maintenance calculator, it will pop up. And I would encourage people to look at that. It's based on a number of nights that the child spends with the non-resident parent, and it's based on their income, their gross income. Okay, and the calculator will formulate something, a figure. It's usually on a weekly or a monthly basis, and that's how much the non-resident parent should pay to the primary carer parent, who the children usually live with. Okay, now there is a threshold that the child maintenance calculator goes up to, and that's usually about £156,000 a year in terms of income. And if it's over that, you're into top-up territory, and that's where Schedule 1 can come into play. So Tara, if you want to touch a bit on Schedule 1 for us, that would be great.
Yes, so unmarried parties who have children together are able to apply under Schedule 1 of the Children Act for financial provision for the benefit of their children during their minority. It can extend beyond their minority if the children have a disability, but on the whole, it is limited to their minority until they're 18. the court has power to make a number of different orders to provide the financial support that's required. The first thing that the court will look at is what is the housing need of the children, and will endeavour to put them in housing that is in keeping, not identical, to the housing or accommodation of the father. I'm using a stereotypical scenario. It may be the mother, and so the other party. The question, first of all, will be, well, how do the parties own the property? And that will be a sort of tellata issue. But let's say that the party has an insufficient share of the property to meet the children's accommodation needs, then Schedule 1 can provide for a further lump sum to be given to that party or settled on them for the child's minority for the purposes of housing. That will have to be repaid once the children turn 18 or sometimes leave university. Okay, so it is just for the children's minority. In addition, the court has power to make lump sum payments for, again, the benefit of the children, but that is quite broadly defined, and it can cover, for example, the cost of a car for the resident parent, repayment of debts that have been incurred by the resident parent on the basis that they've probably been incurred by that parent because they've been looking after the child, the cost of school fees as a fund, for example, if it's a sort of case in which they are payable and can be afforded. And then there is power to order, as Ciara referred, top-up maintenance or child maintenance if it is out of the jurisdiction of the child support service. And that it tends to be either if they're a big earner above 156,000, or if there's a jurisdictional issue, which would mean that the child maintenance service doesn't apply because they live out of the jurisdiction, or for instance, if there's some other reason that the child maintenance service doesn't apply, for example, if there is exactly equal care. So there are a number of different ways that the court can invoke its power to make further orders, and it will be a process where there'll be a number of hearings, including what's called an FDR hearing, financial dispute resolution hearing, which is a sort of judicial-led mediation, I like to describe it, which is a really good attempt to try and resolve things. And I can see from the questions that have been asked on the app or the chat that a consideration for what happens when there are children are really pressing on people's minds. And so I think my one bit of advice is, if you've got a case in which you may or may not co-own a property with someone and the children have a pressing need which you need to meet, then go and get some legal advice to first of all work out what your share of the property is, because it actually may be that you can then meet their needs without having to go through a Schedule 1. We find, don't we, Ciara, that often the two claims are kind of issued together and run alongside each other. But I do say, in a case where there's questionable ownership and where there's a strong kind of needs claim or a potential needs claim for the children, go and get that advice, because it's quite a complicated area, and a lawyer will be able to guide you, because you don't want to be making claims if you haven't got a good claim. It can be a huge amount of money, and there can be cost risks in doing so.
Yeah, thank you, Tara. Okay, we'll move on to the next question, because I think you've answered that one very thoroughly, and we've got 2 left to go, and I want to make sure we fit them all in. So my ex and I are separated, but we still live together because neither of us can afford to move out. they have been controlling and emotionally abusive throughout the relationship, and this is worsening. What options do I have? Again, sadly, this is a very common question that is asked and that I face, daily, with people ringing up and asking these questions. So, I mean, with abusive relationships, it's really important that you get some legal advice first and foremost about kind of applications that you can make to the court and when to make them. You can make applications for two types of orders. There's non-molestation orders that would prohibit someone from using, it's called molesting, but it can cover many different forms. So you can sort of get orders that would stop someone from communicating with you, from coming to your place of work, for example. And then there's another type of order called an occupation order, which you can get, which would exclude someone from the property where you reside. Okay, but it's really important that you get legal advice before you make any of these orders. Okay, Tom, if you don't mind touching a bit on this question for us, that would be great.
Yeah, absolutely. Again, something that's unfortunately increasing. This is one of the kind of the most potentially dangerous situations, because actually if they're already experiencing controlling behaviours and emotionally abusive behaviours throughout that relationship, this is a period of kind of separation where often those behaviours can likely escalate and ramp up. To being in a situation where we feel forced to continue cohabitating and removes that kind of physical safety that distance would otherwise typically provide. So if in a situation, this particular question has been posed, if they cannot physically move out at the moment, what we want to do is still start working towards building a safe exit strategy. Okay, so that we can actually build towards the future. So creating that exit plan, even if we can't leave yet, is still really important to build the self-worth, the self-value, the future focus, and that there is light at the end of the tunnel for them. So getting down to the basics of things of where would they need to go even in an emergency situation, right? Who else can they go to? Right? What important documentation might they need? Passports, children's birth certificates, mortgage deeds, insurance details, a whole host of different accessible documents that they might need. Do they have access to any finances, clothing, etc., that they could also keep in a private, secure, safe place, or ideally with a safe person? Securing other kind of personal items, like I mentioned, documentation and any finances, but also things like phones, email addresses, changing passwords. This is a big thing as well. If you're in a controlling and emotionally abusive situation at the moment, and that is unfortunately likely to potentially increase, right? The level of control will likely become digital if it hasn't already. So ensuring you've changed all those passwords on all accounts, enabled things like two-factor authentication, right? Check for tracking and cloning apps and things like that. Confide in trusted friends or family, right? Someone who is in your corner, your safest person, and also having things like safe code words as well. Right? That could be kind of nondescript that otherwise nobody else would know, right? In case you do need to have a safe exit quickly. Right? Keep a record of the behaviours and the evidences of the behaviour and the abuse, wherever and however safe to do so. Right? Keeping a recording log, reaching out to and having a look within your local area potentially for an IDVA, an independent domestic abuse advocate as well, and also getting the right signposting for other professionals that might be able to help as well. So research kind of local refuge services, other charities, etc. Because in this situation, we need to help you build for what might happen at any moment, but also building up for the future, and hopefully nothing does happen. In terms of other kind of immediate coping strategies and kind of physical boundaries wherever possible, if you have been able to get to the point of having at least some private and separate spaces, do you need locks on bedroom doors, private spaces, right? Spending time out of the home, agreeing that both of you can spend time out of the home, potentially not if they're going to be very controlling and emotionally and etc. abusive, right? Look for how can we minimize that time that you might be alone with your ex as well, and particularly also if you've had children present as well and they're being exposed to this. Right? Building and maintaining our connections externally as well. isolation is a core control tactic. So we need to help prepare for how to resist this. So building those outside connections and having outward focuses can really, really help.
Thank you, Tom. That's so helpful. That's very helpful. Thank you very much. I think Susie's going to pop some links in the chat as well that can help people signposting to certain charities, etc. as well. Okay, moving on to our last question. I'm struggling mentally with my breakup of a 15+ year cohabiting relationship. My friends and family don't seem to understand, as it's not like we're getting divorced. How can I make them understand? And I think, Tom, you're probably the best person to kick us off on this question, because it's a really common theme that we do see, because people who are separating, who are unmarried, do feel like they don't get that kind of public validation.
Yeah, absolutely. Public validation and kind of managing those social circles, as it were. So, what a better word, the lack of that formal kind of ritual divorce process that we've spoken about for married people means that it can land very differently, and for other people, it might feel that often it can, as you say, feel minimized by others, right? That the emotional reality isn't the same or on par or identical. Going back to what I was saying when I kind of very first started, that actually there's a number of research and studies out there that actually suggest and are pointing towards that an unmarried cohabitant going through a separation, due to the heightened situations of that they might not have any ownership of a property and a whole host of different things that we've all just been talking about, that can actually really raise the emotive and psychological impact here, and how that affects them with outside views from others, right? You still lost a life partner, a shared home, shared dreams, a shared identity, and that kind of disenfranchised grief is really deeply painful and can feel really isolating. So thinking about the people that maybe you're experiencing this from, it says, I think they said about family and friends don't seem to understand, right? Helping them to understand in the kind of the right phrase in the right way. So being direct and honest with them, right? This isn't just a breakup. This is the end of, I think, did they say it was a quite a long relationship? Was it 10, 15 years? I think they said.
15+ years, yeah.
Yeah, 15+ years. So this isn't just a breakup. This is the end of a 15-year relationship. We built a life together. We had children, if you had them. We had a mortgage. We had memories. We had holidays. We might not have been married, but we had a marriage, right? And this separate, and also using language like my separation as and my ex-partner rather than ex-boyfriend, ex-girlfriend, because then the language can help convey the severity and the seriousness for it as well. So being specific on the impacts as well. Like you said, we shared mortgages, we shared pets, we shared families, friends. Like, this is all something that we're still grieving as well. And then it's about actually saying the things that we also need as well. So I need the same level of support that you would give someone who's going through a divorce. The emotive pain and the practical challenges are still the same. In fact, sometimes they can actually be exasperated. Please don't minimize this because we weren't married. Like, it still hurts. And again, there might be people that don't get that, and then it's just also starting to recognize about, and divorced people say this as well all the time, so it doesn't matter whether they're married or not. People will always say to me, and they'll say it to you guys as well, like, you find out who your real friends and family are, right? You find out who your tribe is, the people that are really there for you. If they're not getting it, and this isn't about kind of removing yourself, isolating, or cutting people off, but don't feel that you need to justify that to them. Explain it, but if they're still not getting it, then that's okay. It's then about you coming away and actually focusing on yourself, about re-establishing your identity, right? After this breakup of 15+ years, right? Because that identity as a couple, right, without the clear kind of definition of divorce, for a lot of people, it can feel like they're stuck between coupled and single with no roadmap for rebuilding themselves. And it can feel disorientating. So it's then starting to think about understanding that loss of identity, but then how they can rebuild it, giving themselves permission to rediscover themselves, reclaim interests, passions, activities, old friends, new friends, allowing themselves to be a beginner again.
Yeah, Thank you, Tom. And I think what you say there in terms of not having something tangible, such as, you know, your decree absolute or your final order, like you would have in a divorce. But from a legality perspective, there are ways to kind of formalize the breakdown of your relationship, such as a separation agreement, a cohabitation, a separation agreement. And that's something I would really always strongly advise people to do as well, especially if there's property, children, pets, anything. Where really you do want to formalize that and have but again, it is what it says on the tin. It's an agreement that does need to be reached with your ex-partner. Okay, thank you both so much. Let me have a little look at these questions here because I've been so entrenched in listening to you both Tara, I think you covered the first one, so thank you very much. I think there's one more in the chat which I can respond to after. I can respond to that question in the question and answer chat. So thank you very much for sending that through. Last call for any questions. Well, I just want to say an enormous thanks to Tara and Tom. Thank you both so much for your insight, your time and your expertise. Hopefully we have covered everything. Susie will let me know if I have not. And a big thank you to Susie, who's the kind of brains behind all of this and making everything tick. So I think our next breakup club is hosted on the 27th of November. Same time again, 5:30, and it will be on finances and divorce. Not sure who the panel will be, but you both could be asked for an invite back, I'm sure. So look, thank you both so much, and thank you to everyone for your questions, and have a lovely evening, everyone.
Bye.
Bye-bye. Thank you.